All right, welcome back. This is presentation 4 of Chapter 4, Civil Liberties. We've been talking about the various kinds of due process rights. We're going to conclude by discussing what it means for cruel and unusual punishment. And then we will close with a discussion of privacy, which again is one of those compound rights that exists as a result of interpretations of various of the amendments within the Bill of Rights. So the Eighth Amendment protects against cruel and unusual punishment. It reads, excessive bail shall not be required, nor excessive fines be imposed, nor cruel and unusual punishment be inflicted. Nearly all the legal controversies concerning the Eighth Amendment have focused on what constitutes cruel and unusual punishment. In 1972, the Supreme Court dramatically, in the Furman versus Georgia case, dramatically invalidated most state impositions of the death penalty as amounting to cruel and unusual in the same way that being struck by lightning is cruel and unusual, basically arguing that the process by which states sought to apply the death penalty was so arbitrary that it could not withstand constitutional scrutiny. However, after 4 years in 1976 in Gregg versus Georgia, the Supreme Court basically ruled that the state of Georgia, by separating conviction from penalty phases, resolved the court's previous concerns about the imposition of the death penalty. The Supreme Court has long struggled to establish clear principles for determining when the death penalty could appropriately be applied. And right now, basically, there are only a narrow band of typically it's murder with aggravating circumstances where the death penalty is sought. Manslaughter is generally not, you don't generally look for the death penalty there. Rape is no longer considered to be a death penalty worthy offense. There are, for example, people with diminished mental capacity are not considered to be eligible for the death penalty. Again, oftentimes, what constitutes a mental infirmity falls in favor of people being executed. So the Eighth Amendment's ban on excessive fines was among the most recent rights incorporated by the Supreme Court. The right to privacy means the right to be left alone. It is among the most important of the implied rights created by Supreme Court interpretation of the statutes within the Bill of Rights and the Constitution. The power of federal, state, and local governments to assert eminent domain is a balancing act, again, that says, the values of private property ownership are balanced against that of the common good. And if someone may own property that is dilapidated and they can't fix it, and it's in a distressed neighborhood, municipal governments can seize that property provided they provide fair market value. That has oftentimes been very controversial and created a lot of hard feelings, especially again among lower income Americans. In the case Griswold v. Connecticut, the Supreme Court argued, regarding birth control, that a combination of the Third, Fourth, and Fifth Amendment rights establish a zone of sovereignty which include the right to birth control. And so that's pretty much where sort of the privacy issue, begins. Abortion is an issue that is also, related to privacy. In Roe versus Wade in 1973, the Supreme Court confirmed and extended the implied right to privacy in a revolutionary decision that basically said that women had a right to terminate an unwanted pregnancy. The Supreme Court followed both kind of historical and legal precedent. The Roe decision provoked a strong reaction and the organization of a national right to life movement over a 50-year period. Really, public opinion has not moved significantly on the issue of abortion. Solid majorities of Americans continue to think that women should have that right. The Supreme Court overturned Roe versus Wade in the summer of 2021. And at this point, again, there have been a lot of different attempts. In states controlled by Republicans, they have stripped those rights away, and they have, and the result is they've dealt with bad media reports of women dealing with unviable pregnancies being denied access to health care because doctors are afraid of being prosecuted for performing an abortion. And so, again, this is a highly contentious issue. Your viewpoints are going to be dependent on your moral beliefs. Right now, the circumstance is that if you're in California and you're a woman with an unwanted pregnancy, you can procure an abortion, and if you're in Oklahoma or Texas, you cannot. So that is also, again, there is the fact that a woman can travel to a state where abortion is legal. And that continues to be the legal problem. There are some states, I think Missouri has thought about passing legislation to prevent women from traveling to get an abortion, which would be a restriction on the freedom of movement that I think would be unprecedented. And so again, that's these are the Dobbs decision has opened an enormous can of worms that we have still not sorted through. Access to abortion, and again, this has changed quite a bit after 2021. You really have a situation where about a third of the states really have fairly absolute bans on abortion, and then a number of states where there are significant restrictions. There have been a number of states that have attempted to put bans in that have failed through state initiatives. Kansas and Kentucky are two that spring to mind. Sexual orientation, again, the status quo, sodomy laws existed going, again, all the way back to colonial times. Most states believed that it had the power and the duty to punish people who engaged in perverse sexual behavior, and I'm using what they perceived as perversity at that time. The Supreme Court precedent in 1986 in Bowers versus Hardwick basically sustained the constitutionality of laws that discriminated against LGBTQ members of those respective communities. In 2003, the Supreme Court handed down a landmark decision in Lawrence versus Texas that reversed the court's precedent in Bowers, declaring that all Americans are entitled to respect for their private lives. And then in Obergefell versus Hodges in 2015, the Supreme Court ruled that the federal law, Defense of Marriage Act, and state laws banning same-sex marriage violated the 14th Amendment's Equal Protection Clause. Bostick versus Clayton County in 2020, a 6-3 Supreme Court held that the Civil Rights Act of 1964 prohibited employment discrimination on the basis of sexual orientation. Now we have, again, these laws that are attempting to basically make diversity, equity, and inclusion programs illegal, and that is, again, these are attacks on the LGBTQ plus community. They're basically saying that we should have a right to believe whatever we want, and if our beliefs include that people who of the LGBTQ plus persuasion are perverse, then that is our right. That is, again, a can of worms that is being litigated through American courts right now, and we'll have to just see what's going to happen there. So, civil liberties, what do you think? The relationship between government and citizens is delineated by the Constitution and the Bill of Rights. Rights exist in tension with other rights, and that creates a constant need for balancing, oftentimes competing claims. This also generates, the point of our Constitution is to create the maximum amount of freedom consonant with public order, and that requires a certain amount of trade-offs and balancing acts. So how have you experienced instances where someone else's exercise of their freedom interfered with yours? How do you think members of the, of a group, what do you think of the cheerleader that had a little rant on social media? Should her rights, be infringed? These are important questions. In your opinion, what about the right to possess handguns? The state's use of the death penalty, the exercise of religious freedom. What are your rights to act upon your beliefs? If you believe that abortion is murder, do you have the right to engage in violence to prevent abortions from being carried out? How have new technologies affected the government's ability to monitor its citizens? What are your expectations of privacy in your email conversations, social media, your plane tickets, your reading habits? We surrender voluntarily a lot of our rights as citizens because of things that we're kind of required to do as consumers. It raises lots and lots of really important questions that we have to think about very carefully. So that's it for our discussion of civil liberties. When we come back, we will discuss the mirror image of that, which are civil rights. See you next time.